5. Ships and shoes and sealing wax. There is more to the law and to the study of law than the case system. And now that most pressing business is over, and you see at least something of what the study of cases is about, we can sit back more at our ease, give fancy freer rein, and loaf a little in such pastures of the law as the old nag will take us to. There is no end of pastures, logic and legal history, and the register of writs, law on the continent, law among the Cheyenne juvenile courts, Hofeldian analysis, the federal constitution, Bracton and Blackstone, Mansfield, Coke and Bentham, how English law came to America, statutes, the judge in politics, legal research, admission to the bar itself, use of the library, codes, and the law's delay. Let us pick out a few of these and stuff our pipes, touch a match, puff, and watch the pictures in the smoke. 1. Logic. Perhaps first as to the part that logic plays in law. For if you remember, I have been a little hard on logic. There was a view, and I suppose some hold it still, that law is made up of principles and rules. A master craftsman would be able to arrange them in one great hierarchical scheme. At the apex, ideally, stands a single major premise, the grand exalted ruler of the order. Under him Klegels, Claxons, Claws, and so on down to the more ordinary rules of law. Under these ordinary rules, in turn, the cases range. The single sets of fact, each in its due appointed place, each one a term in a minor premise of which the major is the rule that holds its class. In less idealized and ambitious form, such ordering has repeatedly been attempted for particular fields of law. Indeed, what I have urged upon you as the problem of putting a group of cases together comes in essence to the building of a tiny system of this nature for a tiny field. Now, such a logical system of propositions, however modest in scope, inevitably goes beyond the instances in hand. The essence of inductive construction is the building of a major premise, which will include not only the observed phenomena, but all like phenomena as well. The most modest, the most purely descriptive logical arrangement of the rules of cases, therefore, always is broad enough to cover more cases than you start from. As to such further cases, and when viewed still as a system of description, your logical setup now remarks to you as follows. If I am a correct description of the cases, then the future cases A and B will have the outcome X, as have past cases A and B. And cases A and B will also have that outcome. But the future cases C and D will, like their predecessors, have the outcome Y. So will the cases C and D. But in law, your logical system refuses to remain on the level of description, of arranging existing observation. Backed by the fact and doctrine of precedent, your logical system shifts its content to the level of ought. This does not affect the logic. Its remarks change in tone and substance. Now they run. If I am a correct description of the accepted doctrine, the future cases A and B are to have the outcome X, they should have that outcome. And if the judge is on the job, he will see to it that they do. For your logical system has now incorporated into each of its initial data into each decision from which it is built up the ought idea. No longer are these initial data statements merely of how courts have held on given facts. They have, thanks to the addition of precedent, become each one a statement simultaneously of how a court has held, and in addition of how future courts ought to hold. To describe the one is to announce the other, by describing an authoritative command to future officials given by the precedents. The rules that you derive from putting cases together are therefore rules not merely of description, but of ought, major premises from which one concludes that if the rule is correct, a particular further case ought to be so decided and not otherwise. To which is added an implication in fact that the judge in the future case will be on his job. Now, on the level of predicting what will in fact come to pass, clearly there are 3 places to attack your rule as you thus set it up. One may attack it by challenging your logic. You have slipped in your reasoning. You have, let us say, indulged in the lawyer's most frequent logical blunder, ambiguous middle, using the same word symbol in 2 different senses. Or, and here we recur to the level of observation, You may have so built your alleged rule that it fails to cover some of the cases before you, or covers some of them contrary to their holdings. Then not your logical deduction, but the adequacy of your induction is in question. Or, and finally, one may attack you on your implication about future judges. You may have picked a premise perfectly all right as covering your material. You may have deduced soundly the conclusion which follows, and yet your future judge may kick over the traces. To use the language of my last lecture, his attitude may not admit acceptance of your reasoning. And since we have seen that every single precedent, according to what may be the attitude of future judges, is ambiguous, is wide or narrow at need, it is clear that your original induction must either run in terms of the future judge's attitude in this, or else fail to jibe with what he will do. Seen in these terms, it becomes clear that whereas the deductive aspects of your application of a rule once made may be, ideally, perfectly certain, your induction, which proceeds, is one which begins not with definite, but with indefinite material. One therefore into which elements of judgment, hunches, prediction enter as you freeze it into definite arbitrary form to make possible its logical manipulation. And it is clear that in choosing the definite form you give it, you must be guided by the desire that your conclusion may work out in fact in life. You must therefore cut the raw material of your single case according to your expectation about how courts will handle each one of them as a precedent. So far in your role as a non-participant, a business advisor, a man figuring what courts will do in order to arrange his affairs to suit. But as an advocate, as one about to argue to a court, the matter is somewhat different. There, the rule which you derive by induction is a rule which has one striking characteristic absent in the observer's work. In addition to the cases which are given in the books, it must cover the case which you have in hand, and must cover it cogently, and must decide it as you need it decided. Here your job of induction has a predetermined goal, and the inductive reasoning you now put forward is less in terms of what the present court's attitude is than of what you desire it to be, and of what you hope you can induce it to be. This does not change the job of making a logically perfect structure of making what I have called a sound technical ladder to reach the result. But it affects the way in which you deal with the ambiguous raw material of the prior cases. And since your ladder must be persuasive on the deductive side as well, it affects the way in which you emphasize, arrange, classify the facts of the case in hand, to drive home as significant those aspects of the facts which fit conveniently into the premise you have erected, which nail this case down within the rule. Indeed, it is time now to challenge what I have thus far assumed. To wit, that on the purely deductive side of these logical structures, a certainty of conclusion is to be found when you move into the world of fact. Remember again the infinite diversity of fact situations in life. Remember again, in the court's decision, the level of interpreting the raw evidence. Remember, finally, that even when the evidence has been interpreted as to what it means in fact, there remains the job of seeing what it means in law, of putting the individual facts or groups of facts into those legal abstract categories, which are the terms of legal rules. Motor car or vehicle, road or public highway, and the rest. What shall we do with a scooter in a private park? There is judgment to be exercised then, first, in selection of raw evidence. Second, in interpreting or transforming what has been selected. Third, in classifying for legal significance the material after its fact meaning has been assured. And for the advocate there is persuading to be done, not only on the side of induction from ambiguous precedents, but also on the side of deduction, of classifying any concrete facts into the abstract fact categories, which are all that rules at law can hope to deal with. Of a truth, the logic of law, however indebted it may be to formal logic for method, however nice it may be in its middle reaches, loses all sharp precision, all firm footing, in the two battlegrounds in which the 2 feet of the ladder stand. Is this an excuse for sloppiness of logic? It is not. To slip in logic is to curse your case. Even if otherwise good, it then is bad. But to mistake your logic for persuasion is an error as great. Where the material on each end speaks with a forked tongue, there rises against you a ladder of logic as impeccable as yours. And there remains to you the problem of persuasion in your initial building of your ladder and in your argument. So far, we have looked at the relation of logic to the law from the angle of the observer or advisor, and from the angle of the advocate. We have seen how the counselor must add to his logic his understanding of the attitude of the judge, and how the advocate must add not only that, but also the wherewithal to persuade the judge to accept a major premise from which the advocate's conclusion flows. What now of the judge himself? Is he a machine, merely with a set, an attitude, which goes on mechanically, and which an observer requires only to discover? Is he a weather vane which the advocate can blow this way or that? Is he a despot, free of all control, thanks to the leeway offered by the ambiguities of his material, and able at will, or as a favor, or in caprice, or for a price, to throw the decision this way or that? As to this last question, within limits, yes. But much more truly, no. He can throw the decision this way or that. But not freely. For to him the logical ladder, or the several logical ladders, are ways of keeping himself in touch with the decisions of the past. This, as a judge, he wishes to do. This, as a judge, he would have to do even if he did not wish. This is the public's check upon his work. This is his own check on his own work. For while it is possible to build a number of divergent logical ladders up out of the same cases and down again to the same dispute, there are not so many that can be built defensibly. And of these few there are some, or there is one, toward which the prior cases pretty definitely press. Already you see the walls closing in around the judge. Finally, when all is done, he does remain free to choose in a sense, but not free in another, for he is a judge. As a human being, his attitude, the resultant of his life, conditions him. As a judge and a potent factor in his attitude, his conscience conditions him. It is his job to decide which ladder leads to the just conclusion, or to the wise conclusion when he sees two clear possibilities. He does that job, and in the main he does it well. Often indeed he will not get that far. Often the prior cases push so strongly toward one line up that he will not even see the chance we here point out to line them up differently. Then, unless the result raises the hair his hair, not yours, and forces a different outcome to speak at the muzzle of a gun, the judge will never get as far as inquiring into justice. He will decide by law and let it go at that. Particularly, to come back to a point made earlier, will this be true of the weaker, the less skillful judge? Advance upon him with a ladder sound in logic, and he grows uncomfortable. His duty calls for application of the law. His skill does not suffice to find the alternative ladder, which a more able or sophisticated mind might find. Again, we see wisdom made institutional, caught up and crystallized into a working system. By way of logic, the weak judge is penned within the walls his predecessors built. By way of logic, the strong judge can scale those walls when in his judgment that is needed, and either phase and both promote the common weal. Now this ad hoc approach to logic, this building of major premises out of a group of cases, not so much to find what is in them as to decide a case in hand. This is of the essence of our case law system. It is not so of every legal system, even of every system built on case law. The classical jurists of Rome seem, though they worked case by case, to have built up a strangely systematic whole. The French and German writers before the codes had gone a great distance further on that road. Elegantia juris is the Latin for it. Form in the law, in whole, and in each part. Our sin is lack of elegance, and even taste. Our virtue is a sturdy, earthy common sense. From this angle, I think you will understand the attitude of some of your instructors. They show so little interest in the deductive consequences of a proposition. They show no patience in following deductive reasoning through. Put them an inconvenient case within their rule. There is no thrill of battle. The minute they see the inconvenience, they will junk the rule, restate it to avoid the bother, and go on. They do not seem depressed. Students who have had rigorous deductive training are amazed and often are disgusted, I think, with no great reason. Here is a man whose training is ad hoc, who knows our courts to work as he is working. His search is not for a rule which holds at large, but for a rule which holds good for the matter in hand. His interest is in forming premises in consonance with the authorities, and premises which decide according to need the case before him. One is as good as another, ad hoc apart from the question of persuasion. That he is there to teach you, and one thing he can teach you which is worth learning. That is, resilience in choosing major premises. This is a pragmatic world. Most major premises still are dictated by a conclusion needed and already fixed. Not that I would have your training stop at this. You must have exercise in deduction as well. Fortunately, you have other instructors who lay down major premises and work with them, though they tend to be as weak in logic as the others. They, too, are products of their training ground, our law. And our law has had no love for definitions except ad hoc. The more careful of our statutes do include some definitions, but for the law at large, not at all. In this act is as far as they purport to go, and even there, they lack for reason the touch of Puritan courage of conviction. The definitions follow weasel words. Except when the context or subject matter otherwise requires X shall mean A or B or C. Now, deduction without definition of terms is a game of cop and robber. You can have anything you catch. You will find, too, in this academic deductive exercise, as with the legal writers, that what we have seen as a most difficult, ambiguous task is regularly slurred over. To wit, the allocation of the raw facts among the generalized, significant categories of the law. In short, on the side of logic, our law has much to learn, and we, your instructors, not a little. But as I hope I have indicated, that does not mean that you can get along without it. It means that you have a chance to improve on the techniques, now current, if you will season your logic at each end with knowledge of the cases, and with common sense. From this angle, moreover, you will observe another value in the study of the cases. Each opinion is an example of legal reasoning with, and from prior cases. Each opinion is an example of what some court has thought persuasive. Both as to the legal use of logic, and as to persuasion, there is something here to learn. And please note that there is as much almost to learn from the poor reasoning as from the good. A fine opinion is a model piece of work. But an execrable opinion gives an example of a type of mind you have to deal with too. In this connection, too, I should like to ask you to observe the difference between logical argument and argumentative statement, between showing a given logical relation between two matters, and persuading someone else that it exists by attributing the relationship to them in your discussion or description. This appears nowhere more strikingly than in the presentation of the facts with an eye to the rule you are trying to bring them under. Allied in technique, but different logically, is the use of emotive words in your argument, which are designed to induce the attitude toward the result your argument requires. The crass case, as you already must have seen, is in old-fashioned pleadings. Watch for these things in the judge's opinions. Not always, but often, they mean that defective logic is being covered up. 2. Rules, practices, policy, statutes. Now, having raised the question of rules of law as rules of ought, rules which tell judges and other officials what to do, and having in my first lecture argued that the law really was not so much rules as what the officials did, I fear I must wrestle with the relation between the two, and at the same time with the place in all this scheme of statute law. Perhaps the best approach to an answer will be to backtrack a little on the assertion in my introduction, and to assert instead, so to speak, as a corrected hypothesis, that law must embrace in its very heart and core what the officials do, and that rules take on meaning in life only as they aid one either to predict what officials will do, or to get them to do something. Or, if you prefer to state the dispute aspect of law broadly enough, to include the most primitive forms of law within the group, and the still primitive forms of law between the great groups we call states. That a heart and core of living law is how disputes are in fact settled, and that rules take on live meaning only as they bear on that. But whether you go with me in this opinion or not, you will surely agree that rules and results both will need attention. That is one thing, and that the two must never be confused if you are to see what you are talking about. or where you are going. That is another. It will pay you to observe here and to sever off one by one what we may call the levels of discussion about law, especially in a case class. Cross-level discussion is never profitable. One must be conscious, always, of which level he is talking on, and which level the other person is talking on, and see to it that differences in level are corrected. One must, moreover, know and signal his shifting from one level to another. Else false issues, cross-purposes, and general footlessness ensue. There is first the question of what the court actually decided in a given case. Judgment reversed, and new trial ordered. And the question of what express ratio decidendi it announced. These are facts of observation. They are the starting point of all discussion. Until you have them, there is no use doing any arguing about anything. 1b. There is the question of what the rule of the case is, as derived from its comparison with a number of other cases. This is not so simple, but the technical procedures for determining it are clear. Skilled observers should rather regularly be able to agree on 2 points. The reasonably safe maximum rule the case can be used for. II. The reasonably certain minimum rule the case must be admitted to contain. 2. As against both of these, there is the question of the manner, attitude, and accuracy of the court's interpretation or transformation of the raw evidence. Here judgment factors enter, and you and I may not agree about it. But at least we can keep the level of discussion separate from the levels just above. There we presuppose facts as they result from this interpretation we are here discussing, and we look to the rule laid down upon the facts already transformed. 3. There is the question of what the probable precedent value of the case is in a given court or in general. Here, too, judgment factors enter very largely, and objective agreement is not to be expected. For we must draw into our thinking the results of our work on the second level, and must draw further things as well. Yet here too, as to the level of discourse all can agree. It is a question of predicting what some court will in fact do. You can phrase this, if you will, in terms of ought. What some court will understand this case to tell it to do. I think this latter phrasing slightly misleading, and certainly cumbersome. But defensible it surely is, for there is the question of estimating what consequences the case and its effects on other cases will have to laymen. The relation between the ways of the court and the ways of those affected by the court. This I take again to be purely on the level of description or prediction, but to be a very complicated matter, and one which involves even more information from outside the cases than does problem 3. The consequences may turn, for instance, on the persons concerned making quite inaccurate prediction of how later cases will eventuate on their quite misinterpreting the case, on their readjusting their own ways, not to their actual environment, but to an imaginary environment of court ways. 5. There is the question of evaluating the court's action in the case of concluding how desirable it is. And this is, of course, the most complicated of all, because it includes all the foregoing, and various premises also as to what values are to be taken as the baseline and the goal. What is utterly vital to see at least is that you cannot begin on this until you have settled the matters in the first and second problems, and grappled with those in the third and fourth. And finally, that this matter of evaluation, while it presupposes the others, in no way touches the level on which they are discussed. 5b. There is the evaluation of the court's decision or ratio from the angle of doctrine. Here some premise or concept is assumed, as authoritatively given, and the court's action is tested for whether it is or is not dogmatically correct when compared with that premise. Less dogmatically minded thinkers use the same technique, on the same logical level, to see not whether the case is correct, but whether it squares with a given hypothesis, either of doctrine or of prediction, i.e., to test its consistency with some formulation of a rule derived inductively from other cases. It should be clear that this touches neither 3 nor 4, nor really even 5a. Now it would be a case-hardened theorist who proposed to exclude any of these problems from the field of law. Yet I think it equally clear that central to them all is the question of what the courts will do. I think it also clear that after study of a group of cases and estimates of just how far courts do follow what prior courts have done, one can set about constructing generalized statements, generalized predictions of their action. I have no hesitancy in calling these predictions rules. They are, however, thus far only rules of the court's action. They are statements of the practices of the court. Thanks to the doctrine of precedent, the courts themselves regard them also and simultaneously as rules for the court's action, precepts for the court. So far, the two phases of prediction and of ought cover identical territory. Yet the moment that you forsake the relatively solid rock of attempted prediction, you run into difficulty, and for this reason: that when you are told by anyone that a given rule is the proper rule, not an accurate prediction, you are dealing with his value judgment, based on no man knows what. If you will keep that fact in mind, and your own feet on the cases, and if you will remember especially that the only test of whether and how far a rule authoritatively prevails as a rule of ought is, how far will courts follow it, then you will be safe, whatever language is employed. How shall I reconcile this position with the fact of statutes? We live under a regime of theoretical separation of powers. So far, at least, that theory holds true in fact, that courts and legislatures agree that when legislatures properly pass statutes, the courts are bound by them. But statutes are rules, they are forms of words on books. Now, the essential differences between statutes and the law of case decisions are these. A judge makes his rule in and around a specific case, and looking backward, the case shapes the rule. The judge's feet are firmly on the particular instance. His rule is commonly good sense and very narrow. And any innovation is confined regularly within rather narrow limits, partly by the practice of trying hard to square the new decision with old law. It is hard to keep daring innovations even verbally consistent with old rules, and partly innovation is confined through conscious policy. Case law rules, though new, are applied as if they had always been the law. This derives from our convention that judges only declare and do not make the law. Knowing that the effect of their ruling will be retroactive, and unable to foresee how many men's calculations a new ruling may upset, the judges move very cautiously into new ground. Then, when a case has been decided, it enters into the sea of common law available to any court within the Anglo-American world, and peculiarly within this country. Finally, and important here, case law is flexible around the edges. The rules are commonly somewhat uncertain in their wording, and not too easy to make definite. Else why your study? But statutes are made relatively in the large, to cover wider sweeps, and looking forward. They apply only to events and transactions occurring after they have come into force. That element of caution disappears. They are, moreover, a recognized machinery for readjustment of the law. They represent not single disputes, but whole classes of disputes. They are political, not judicial in their nature, represent readjustments along the lines of balance of power, decide not single cases by a tiny shift of rule, but the rearrangement of a great mass of clashing interests. Statute making, too, is confined within what in relation to society at large is a straitened margin of free movement. But in comparison to courts, the legislature is a horse without a halter. Finally, statutes have a wording fixed and firm, and their effect is local for the single state. You cannot reason from a statute to the common law. The statute of one state affords no ground for urging a like conclusion in another with no similar statute. If anything, the contrary. The presence of a statute argues rather that the common law was otherwise in the state of the statute and hence everywhere. Well, say you, these statutory rules with their fixed words take us wholly out of the prediction problem. Here is ought, naked. That, I fear, I must doubt. For the very basis of this statute is its generality. Made without any particular case in mind, or in some instances, with a single particular case too much in mind, and without the caution drilled by experience into the judges, the language is faced now with a succession of particular cases. And as with the problem of deduction raised above, the question is that of classifying these new ambiguous concrete facts. Do they or do they not fit into the statutory boxes? The meaning of the statute in life, like the meaning of a case law rule, turns on the answer. We must turn to prediction, then, of what the courts will do if we would read the statute. We turn, if we can, to what the judges have already done to make our prediction sound. I am not touching here the Constitution, the power of the judges to set Constitution above legislation, and to deny that a given statute has validity. I am dealing with the meaning of a statute which by the judge's announcement and practice they hold to bind themselves, and which they set out merely to apply. Much of the situation I describe is inherent in the nature of the case. We meet it abroad, where statutes have been drawn with prayer and skill, and judges deemed themselves for years to be almost mechanical interpreters. Even there, we find that it is to decisions we must turn, much of the time, to make out what the statute means, and that the Continentals have awakened to that fact. But in our system, there are further reasons. First, to get it out of the way, we have so many statutes, which are drawn so poorly that it seems doubtful whether the draftsman knew what he wanted, much less what meaning he has put into his words. This evil lessens as the practice of official legislative drafting service grows. But second, we have with us still the relics of a sort of feud between the courts and the legislature, a pride of office, a pride in prestige, a jealousy of skill, technique, of trade. Courts once saw the common law as a coherent system, filling the whole universe of possible disputes with sound solutions. But statutes were single innovations, intrusions upon this system, warts on the body of the common law. Systematic, complete, exclusive codification of the law is strange to us, though the Continentals know it. We see single statutes warts. We treat them thus, partly with reason. Statutes surely require to be fitted in. They cannot stand alone. No language stands alone. It draws life from its background. Technical terms used in a statute undefined must draw their meaning from the law which brought them forth. Only the background of the case teaches what the law was which the statute maker sought to clarify or change. Against that background, then, his meaning must be sought. If you have doubt of this, turn to some clarifying statute, such as the Sales Act, excellent legislation, about a subject, sales of goods, with which you might suppose any businessman familiar. Read over 10 or 20 sections, in ignorance of the cases, and see how little they tell you. Finally, the statute must, as I said, be fitted into something. The fitting can be accomplished only by bringing the two together. The necessary accommodation must in part be mutual. The legislature can hardly be deemed, with its single aim in mind, to have willed the wrenching and ruin of all neighboring existing law it did not mention. But in another aspect, this antagonism to the statute has far less point. Statutes are passed precisely to the end of change. Then they should be given scope. Filling a statute out with meaning from the common law is one thing. Emasculating it by artificial construction is another. I suspect, as I have indicated, that pride of skill and jealousy had some part in producing that great maxim that statutes in derogation of the common law are to be strictly construed, which means, are to be made to mean as little as they can be made to mean. Some other part is almost surely due to the training of the judges in reading any writing. First, as property lawyers, holding a conveyance down to the closest confine of its terms, what man would grant away more than he need to? Second, as skilled special pleaders, trained to construe the papers with all cunning against the party who had put them out. It is hardly needful to point out that most of the wordiness of our older statutes reflects this duel of wits against unwilling courts. On the other hand, we have another maxim of more recent importance. Remedial statutes are to be liberally construed. This represents a better insight. But observe here, as in the case of precedents, as throughout the law, the two-faced premise legal technique offers to the judge. At his need, as the case before him urges, he can construe the statute strictly as in derogation of the common law, when it would seem to work hardship, or liberally as remedial, if that seems indicated. One more thing I must mention before I leave these statutes. If they are local, territorial in their effect, if they afford no ground for reasoning to the reservoir of law, Then when you meet a statute in a case, you can skate over it. It has no general bearing. It need not be remembered. As pure information, it may be you will not need it, unless like statutes show signs of appearing elsewhere. But as a problem in legal technique, a statute in your case book deserves more intensive study than a common law decision. For whatever the concrete content it may have, it presents to the court a problem. How to interpret what to do about it. As to that problem, the court's approach and solution are typical of all our courts, typical of a process you must know, and of a process which you cannot follow except in its abominable detail. You cannot read a statute like a case. There is no pleasant repetition of the same thought in different forms. Each word stands there. You get it, or you miss the whole. There is nothing that one dares to scant. There is little indeed of dictum in a statute. Eyes out then for each word of each statute that you meet. 3. Rightness, rights, hofold. Looking back, I see that I have spoken about how courts ought to construe statutes. I doubt not that on several occasions I may have skidded into remarking on what courts ought to do. Law has so long been dealt with as a question exclusively of ought that it is hard going to run one's thinking onto the level of description and to keep it there. Yet it will not do either to remain exclusively upon that level. So far as law officials order the affairs of men, we must take account too of how we wish that ordering done. Some of us, more ambitious, will insist on having the ordering done right. Others may wonder who knows what is right and how he can tell it. Yet will insist no less vigorously for that on their own best judgment as to how the ordering ought to be. This level, which I shall call that of social values, has always centered the attention of outsiders who thought about the law, the man in the street, or the philosopher, the political scientist, or the reformer. Partly this has been a matter of mistaken economy in thinking. Rules are easier to see than their effects. It is easier to seem to get ahead if you take will for deed, rule on the books as equal to activity. Partly it has been due to the nature of the subject. What we want from law is results, if we are laymen. Results in social ordering. It is the business of the lawmen to produce results. The citizen's business is merely to instruct them what to do. Lastly, the lawmen themselves have through the ages lent themselves stature as the priests of what is right. It suits the dignity of the law to pitch discussion upon the moral plane. I find a nobler dignity in digging ditches. I find planes high as they result in action, in effective action on a level each day, a little higher than the day before. This, however, is a personal vagary. It interests laymen little, and most lawmen less. So I return to what is of common interest, the right way of law, the legal right. And here at once you will find great confusion. Right as applied to law, as used by some, will mean just or correct, morally sound or socially desirable. Right law in this sense is justice. As such, it is a matter of debate. People do not agree on what is just. We can limit the disagreement somewhat by distinguishing between social justice, justice in the whole setup of society, and what I shall call legal justice, justice so far as it is possible within the framework which society at any given time has set. Any one man's views on the two will be related, yet his demands on the second must be more modest than on the first. On the side of social justice, he will criticize the law entire, and indeed the other institutions of society. He will attribute to them much evil that is in them. He will attribute also to them much misery, which nature, not society, must answer for. His appeal will be for legislation, or constitutional amendment, or for revolution. But on the side of legal justice, he must address and criticize the courts. And if he has sense, he will see that the courts must move within the framework of the given rules. The rules, however socially unjust they seem to him or others, still are there. The court is in part their mouthpiece. What it can do, all it can do, is to soften a little here and there in a detail the rigor of the general scheme. Here, too, there will be room for dispute. Those who voice criticism of the general scheme, in gross or in a fraction, will call for the court to move to the full limit of its powers or beyond. Others will cry wolf if the court seems to budge a hair. But most on both sides will lack what I have spoken of as sense. They will take no distinction between legal justice and social. They will demand all of both kinds, and in their own desired shape, and at once, and from all law officials, courts as well as others. If they fail to get it, they will curse the law. In one way, it is well that this is so. A fighting sense of injustice in the law will unchain forces for reform, which a dispassionate weighing well might leave quiescent. On the other hand, he who sees clearly how the matter lies will, if he moves into battle, do more effective and more lasting work. All of which touches us here, because almost everyone who deals with law introduces at some stage of the discussion his notion of the justice or correctness of the court's actions and the rules laid down. And because in so doing he rarely distinguishes, and still more rarely makes express, which kind of justice he is talking of, legal or social. And because he even more rarely makes explicit what the assumptions, the premises of value, are from which he argues to the justice or injustice of particular cases. Which means that he gives you no idea of whether it is wise to follow him. And finally, this applying peculiarly to legal writers, because his judgment once made on justice or injustice, he becomes commonly imbued with a valor to defend his view, which keeps him from seeing, or discussing, or duly weighing, the cases and authorities which tell against it. We could forgive him for omitting the arguments of policy against his view. But it is harder to forgive him when he misrepresents what courts are really doing, in his zeal to persuade them to do something else. And few indeed are the writers who can be acquitted of this charge. The question of justice and legal right requires to be opened up for another bearing it has, a bearing even more directly practical. Legal rightness leads to the question of legal rights, and legal rights to rights at large. And rights is a phrase that drips confusion. In the first place, as between law and non-law, as between matters having to do with courts and matters not concerning courts at all. For rights are in common language, often indeed in court opinions, aspects of action or relation which are desirable and are socially approved. Now, don't you think I am within my rights? All I want is my rights. These have to do with what I want or do, and with a social approval of my want or action. I have a right in this sense to what people think I ought to have. Yet it is clear that these matters may not touch the court, may indeed bring the court to act against me. I may be socially approved when I insist on the deal passing to the left, or stop you as you lead from the wrong hand. I may be socially approved when I chase and beat up the man who threw an onion in my eye. The one the court will not notice, the other it will fine me for, so that in legal discussion one must start early, and be vigorous in limiting the word right to matters purely legal. We have another term apt enough to denote the things you want, or need irrespective of the law. An interest. This, however, is not all. Rights in law are as in non-legal usage beneficial. And as in non-legal usage, they are thought of as pertaining to an individual. He has rights. The law, in this sphere of thinking, is conceived as made up of rules. Out of the rules flow the individual's rights. The rules which breed rights are peculiarly the substantive rules, the rules which are conceived to direct the course of action in society. If a right is infringed, you then have, as a remedy, a different kind of right, a right of action, a secondary right, a right to recover damages. You will see that the contents of the primary right and the remedy right are different. As a primary right, my right is to have you perform your agreement, or keep off my land, or refrain from striking me. But in all these cases my secondary right is likely to be merely one to damages at law. At this point you come upon a division of opinion among those whom you may call the happy idealists and the black-visaged cynics. The idealists, and they, by the way, are orthodox and powerful, and have in this matter controlled the legal thinking of the past, see primary rights, my right, e.g. that you perform your agreement with me almost as things. Almost, these primary rights are real. They are the substance of that insubstantial thing, the law. The idealists therefore have no great difficulty in thinking of you as having a perfectly good right, which simply because your only witness dies is unenforceable. It is only the secondary thing, the remedy, which has failed. The right remains to comfort you. Remedy's secondary rights, even in the absence of such misfortunes, may be so set up that they are inadequate. You cannot net at law the full value of your primary right. That, too, to the idealist is unfortunate. But it is non-essential to the right, the lunatic, the lawyer, and the lover, or of imagination all compact. The quotation is spurious. But Shakespeare wrote before this theory of rights was born to write of. The cynic, on the other hand, says, a right is best measured by effects in life. Absence of remedy is absence of right. Defect of remedy is defect of right. A right is as big, precisely, as what the courts will do. The differentiation between substantive law and adjective procedural law is an illusion, although the prevalence of this illusion, as of any other, has results in human behavior, and must be taken account of. What the idealist calls substantive rights are not things, not even shadowy things. They are purposes the legal officials have set themselves, to get you to perform your agreement, to keep you off my land. But the law can be seen only in its effects. Surely it is useful to measure the effects by the purposes, to see the effects, to line them up for seeing in terms of purposes. But once more, let us not mistake words for results. Words, rules of substantive law, concepts of rights derived from them, these may be a good first step. They may be necessary to the goal. They are both. But they do not get us there alone. Let us go on. You will have observed that I hold with the cynics. Yet even if you go with me there, you will have to become intimate with the other point of view. For it is a point of view which has repeatedly shaped court decisions as well as legal writing. In addition to this quarrel between the idealists and the cynics, or the orthodox and the realists, give them what names you will, there is another quarrel which centers about rights, that over Walter N. Hofeld's analysis, as further developed by Arthur Corbin and Walter Wheeler Cook. Space is too short here to do justice to the row. I shall present the thing, or a part of it, in briefest outline. I am of those who think it has great merit for your legal study. In essence, the matter is this. Legal usage of technical words has sinned, and does still, in two respects. It is involved in ambiguity of two kinds: multiple senses of the same term, and terms too broad to be precise in application to the details of single disputes. First, it does not use terms in single senses, but uses the same term in several senses, and in several senses indiscriminately without awareness. This invites confusion, it makes bad logic almost inevitable, it makes clear statement of clear thought difficult, it makes clear thought itself improbable. No logician worth his salt would stand for it. No scientist would stand for it. But law is rooted in tradition, and legal terms of art are in large measure borrowed from lay speech. Trust, agency, sale, contract, offer, revocation, negligence. Some of the lay flavor clings still to the terms, and sometimes more, sometimes less, sometimes the nutmeg, sometimes the salt. Even as to terms purely legal, a similar ambiguous usage prevails. A system which moves ad hoc owns no academy to refine and make precise its terms. First, then, ambiguous terms, and second, terms too broad. Contract, trust, agency, sale, property. Each term comprises hosts of connotations. They are unusable, said Hofeld, as common salt and quartz to chemistry. Surely one can find smaller common elements whose varied combinations make up these larger complexes. He found a number, described them, defined them, showed their interrelations, gave them unambiguous names. And these smaller common elements, in essence, prove to be subdivisions of the concept right, as found in common legal use. I should say here that I shall now present Hofeld from the standpoint of the cynic, whose views I have described above. I am not sure that Hofeld would approve, but I must labor to improve upon my teacher, as you, I trust, will labor to improve upon yours. Vital for use here are three of Hofeld's major groupings: right or claim, in the narrow sense he chose; privilege or liberty; power. Very briefly, as Corbin puts it, a duty, the other end of a right, is what I must do. A privilege is what I may do. A power is what I can do. A right, then, is what some other person must do for me. Now in this setup, the must and the may and the can all have reference only to what the courts are likely to do in the situation. Must do, or have the court on your neck. May do, and not be bothered by the court. Can do, and so affect what the court will do. Let us take up these narrow concepts one by one. A man has a right only in regard to another man. All of these legal relations are relations between persons, and only between persons. There is a person on each end, always. A has a right that B shall do something, I repeat. When should B fail to do it? A can get the court to make trouble for B. But the right has B on the other end. The right is indeed the duty, a duty seen other end to. The relation is identical. The only difference is in the point of observation. If you look at the man whom the court may smite, you see it as a duty. If you look at the man who may call upon the court to smite the other, you see it as a right. You see the same elephant in either case, whether he look like a wall or like a tree. If B has a duty to it to do something, that means that, should he fail to do it, A can get the court to make trouble for B. Now observe what this means to the cynic. Performance of the so-called duty, be it to paint a house, as I agreed, or to refrain from calling you a thief, or to fence my cattle in from your garden, is to the cynic but a certain line of action or abstention which will keep the court off the duty-bearer's neck. There is, to the cynic, no content to the duty as such at all, nor any moral force. To him it is a matter of pure prediction about the court. Unless I paint the house, the court may climb my frame. The measure of the duty, on the other hand, is very clear. It is twofold. How hard will the court climb, if it climbs at all? How likely is the climbing? With decrease in either vigor or probability of climbing, the duty dwindles. Which is to say also, the right dwindles. For practical purposes, it may sometimes be convenient to talk as if the probability were a certainty, and as if the frame climbing were precisely as uncomfortable as the conduct necessary to prevent it. But it never pays to lose track of the fact that for any individual duty bearer the degree of probability and the extent of the climbing are of the essence of the situation. Just one last thing. There is one, and only one, certain test of whether a duty existed on the facts assumed. That is, a judgment by the court in favor of the claimant and against the defendant on the claim in question. This, you observe, by definition. A judgment for the defendant is ambiguous in regard to duty. It may mean, there never was a duty, e.g., the defendant never made the promise, or the promise was without consideration, and so of no interest in law. Or it may mean, although there was a duty, the defendant has done all he had to. Performance. Or it may mean, the plaintiff has on his part failed to do what was necessary in order to make the defendant's duty become immediate. E.g., the plaintiff insists on getting the goods without offering the price. Or it may mean, the plaintiff has slipped in his procedure, and it becomes unnecessary to determine whether there was really any duty on the defendant or not. But a judgment for the plaintiff always indicates a duty, as does a judgment for the defendant on a cross-action in which he acts in substance as a plaintiff, and the procedure simply allows two cross-claims to be tried at once, for convenience, because both are based on pretty much the same transaction. So far for the right duty. And Hohlfeld would remind you to always look for the duty before you use the term right. Who is the particular duty bearer you have in mind? Can you phrase the conduct expected of him to correspond point for point and line for line with the conduct to which you say the other party has a right? If not, says Hohlfeld, you are not talking about what I call a right. Have you a right to use your watch as you wish? Then who bears the duty on the other end? Everybody, each one with a duty to let you alone, or not to interfere. Does not interfering by X correspond with and cover your using your watch? Something is out of kilter here. What is it? Hohlfeld would answer by turning to his second grouping. Privilege. Using your watch as you wish, says he, is not a right at all, but a privilege. It is not a case where you can kick if the other party fails to do something. It is a case where the other party cannot kick if you do something. The situation differs wholly from the right duty. It is not one measured by the prediction that unless something happens, the courts can be spurred to action. It is one measured by the prediction that even if something happens, the courts cannot be spurred to action. When I can act and be safe from courts, I have a privilege. But a privilege, too, has a definite person at its other end. The privilege seen other end too, Hofeld called a no right. When A has a privilege to smash A's own watch, B has a no right about the smashing. I think you will see this more clearly if you substitute the term no kick. It is not elegant, but it is useful. It brings out graphically Hofeld's other point, that privileges like rights in tort commonly come in huge bunches, all alike in content, all different only as to the persons at the other end. I have a vast bundle of privileges to destroy my watch. One is against any person you can name. Each person you can name has no kick if I do. But I might contract with B in particular to sell him that watch. Thereafter, though I retain my prior privileges as against you and C, and an infinity of others, I should have lost it as against this one prospective buyer B. Now you begin to see the utility of Hofeld's thinking. It looks very cumbersome to conceive yourself as dragging 1,000 bundles of 1,000,000 privileges, each as you pass through the daily round of tying up shoelaces, eating lunch, and smoking cigarettes. But Hofeld, for all his theorizing, was a practical man. His mind was on the cases which come before the courts. In each case, one plaintiff, one defendant, one issue. One privilege or one right is all that needs examination. The one relation between these two people. And here, surely, thinking is greatly clarified when one limits A's right to the other squint along B's duty, and makes A's privilege, the other squint along B's no kick. Privilege becomes of immediate interest in your work in torts. A strikes B. He had a duty not to prima facie. But B was assaulting A. A struck in self-defense. Then he was privileged to strike B. B has no kick. The court gives judgment for the defendant. The cataloging of your cases will be clearer than if you say I had a right to strike B, but can find no damages for it to get. The analysis of your cases, too, will be clearer, for if a judgment for the defendant is based not on a procedural slip by the plaintiff, but on particular facts, then something in the facts assumed is held to have created a privilege in the defendant, whereas it cannot possibly be held, under the strict doctrine of precedent, to have created any right in anybody. In contracts, on the other hand, you meet especially Hofeld's third category of relations. It differs greatly from these other two. Right, duty, and privilege no kick are, so to speak, the elements of the existing legal status. They deal with a world which can for a moment be deemed at rest. Power liability, the third category, deals with a dynamic world, with a change of the legal situation by men's actions. Power liability looks ultimately toward the creation of the conditions we know as right, duty, or privilege, no right between two people. But as yet that anticipated creation has not occurred. For the purpose of considering powers, then, we depart from our cynic's point of view. We assume, for the moment, and for convenience, that rights and privileges are something in order more conveniently to mark off the different steps which lead to our predictions about what courts will do. In regard to your thinking and talking, this is perilous business. I hope, however, that we may weather the storm. Power, says Hofeld, is the situation when it can in some significant manner change some one of B's legal relations, any one of B's legal relations. Power, therefore, is a prediction 2 steps removed from the action of the court. Most powers, like most privileges, are unimportant. We can conceive them if we will, but there is no point in willing. It makes very little difference that I may be said to have a power to create in you, by assaulting you, an immediate right to damages against me which you did not have before. What is important is the duty aspect of the situation, not the power aspect. Yet, when the question is whether I have a power to break my contract with you, and thus not only give you an immediate right to damages, but limit you to damages as of a given date, the power concept serves to bring out much more clearly what the so-called right to performance really was. And in many fields the power concept is extremely valuable. Thus, when I make you an offer, I create in you a power to accept. and the whole negotiation between us gains clarity if we think of it in terms of what you now, by your sole act independent of me, are able to accomplish in changing our relations with each other. But it will not do to forget the power seen from the other end, that of the man whose legal relations may be affected by the other, the passive party in the situation. He is said to have or be under a liability that the change in relations, say acceptance of the offer, will occur. The term is stripped of its unpleasant business connotation. I may want sorely to have you accept my offer. The term liability here looks to be one thing only: that some act of one man of his own motion will change some legal relation of another. The man thus exposed is under a legal liability. Now, as to the utility of these strange terms to you. The cases are complex, hard to compare, so many facts, so much talk. It is hard to get at the nub of each. It is even harder to get them schematized, so as to get their mutual bearings clear. But in each one of your cases, if you look closely, you will find the issue centering about some one of these Hofeldian categories between two distinct people. Was there a given duty, or was there not, to the plaintiff? And has there been failure by the defendant in performance of its content? Was there a given privilege, or was there not, and the defendant to do what he did, as against the plaintiff? Was there a given power, or was there not, and if there was it duly exercised? Some one of these is in the center of the fight, and thinking thus, in nicer terms, with nicer tools of thought, you pull the issue into clarity. Thinking thus, you pull a series of issues into clarity for comparison. You see sharply how each decision bears upon the others. Unambiguously, because your terms are not ambiguous. Precisely because your terms are very narrow. Then when it comes to putting larger chunks of law together, instead of slithering hither and yon with general terms whose content changes under every context, you build your general concepts up out of these unambiguous bricks and have a clear-cut whole. A whole with which you can work, because you know its parts, you know its structure. Contract is a duty of a to be or be to a more normally both at once, which arises out of some kind of agreement. But observe, first, that even if both duties should be present, as in an agreement to buy and sell, only one is likely to be in litigation in any given case. And how do you know that the court will not let A recover from B, while refusing a recovery by B from A on the same facts? You will have to deal with the duties one by one to find out. Moreover, your contract, you will observe to have been formed, ordinarily, by a series of remarks exchanged by the parties. The courts talk of these in terms of offer and acceptance, but you will see the situation much more clearly if you watch for what situations give B on his own motion the power to do something to A's legal setup, and then ask precisely what effect B can have on A's legal setup, and precisely how he must act to have it. For you then discover that even after acceptance, B still has powers with respect to F for all the world like the power to accept, save only in this, that they mostly are not revocable at A's will. A has lost the power to revoke. Yet we may be still far from any immediate right of B that A shall do anything. Contract, under this analysis, loses its vague simultaneous attempted application to 100 cases. It grows definite because you see its constituent elements. You must make it grow definite because it is these constituent elements, one by one, and not contract in block, which appear in, which are the turning point of, the individual cases that make up the law, and which will make up your work. 4. Trial courts. People. There is one more matter to take up before we cease our talk of sealing wax and cabbages and kings. It is the most important matter in all this odd lot jumble of importances. It has to do at once with the apperceptive mass, and with what law is, and with what lies behind the case, and with the relation of adjective to substantive law, and with the relation of your study to your practice, and of both to the world at large. That matter is the almost hopeless bias of all present and past discussion about law. We talk of legislatures and of courts of last resort. We talk of almost nothing else. You find me trying at great length to make you see what lies behind the case. For its own sake? Not at all. Only to make you understand the opinion in the appellate courts. You find me trying to analyze the work of courts and judges, criticizing here, moved there to admiration. What judges? Judges of appellate courts. You find me dealing with the law and what it is and does. I say its center is the action of officials, all law officials, and no sooner say it than I slip off my own platform to land for lecture after lecture in discussion purely of these courts of high review. What they do. Surely, it is clear that I am damned out of my own mouth. If, as I claim, what appellate judges do is vastly more important than what appellate judges say, that can be only because importance to other people, to the layman, to the poor devils to whom they do it, appears to me the primary measure of importance. And on that basis, surely you should ask me, how many people do appellate courts affect? For 1,000 cases appealed to the court of last resort, there are 10,000 which stop at the intermediate court of review. For 1,000 which reach the intermediate court, there are 10 or 20,000 which go wholly unappealed. More. For 1,000 cases on trial in the higher courts of trial, the county court or circuit or supreme, there are again 10 or 20,000 settled finally in some lesser court of trial. A small claims court, a municipal court, the court of a magistrate or justice of the peace. Here, in this moving mountain of the cases unappealed, is the impact of the officials on society, even within the realm of litigation. Beyond, there is the massive impact of the administrative machine. By my own showing on my own premises, these are what count. I pass them by, out of my own mouth, damned. Yet what can I do? I am a prey, as is every man who tries to work with law, to the apperceptive mass. I see best what I have learned to see. I am a prey too, as are the others, to the old truth, that the available limits vision, the available bulks as if it were the whole. What records have I of the work of magistrates? How shall I get them? Are there any? And if there are, must I search them out myself? But the appellate courts make access to their work convenient. They issue reports, printed, bound, to be had all gathered for me in the libraries. The convenient source of information lures. Men work with it first, because it is there. And because they have worked with it, men build it into ideology. The ideology grows and spreads and gains acceptance, acquires a force and an existence of its own, becomes a thing to conjure with. The rules and concepts of the courts of last resort. And there is more to the matter than this. It does remain true that if a case is appealed, it is the appellate court whose word is the last word, the word that counts. We cannot then neglect it. In large matters, which will pay appeal, we can, and must work with the high court in the forefront of our minds. Even in small matters, we have seen that the rules of appellate courts are good to press upon the lower, that the lower court attempts to give heed to them, that with them we may bring the lower court to see our way. There is excuse then, there is reason, for fixing attention on these upper courts. But is that either reason or excuse for stopping with them? What warrant have we for assuming that even the judicial system alone, I say nothing of the administrative, works with any unity? We look at our highest courts and find their words a long way from their doing. In their own work, we find that we can trust their rules part way, but part way only. In their own work, the drive belt slips between rules and results. Must we not then assume a further slipping as the distance grows, and as we move down the line? At each stage less exalted judges, at each stage more of them. Are we not to guess that the average of ability is lower too? Are we not to guess that other factors join in giving the wheels their drive, as the factor of high court rules slips more and more into ineffectiveness? That the interplay of belt and gearing turns the machine in strange, unsuspected ways. Ignorance, prejudice, accidents of experience, favor, indolence, even corruption. How much, how often, when, and where? How far, too, does the setup of the procedural system stand between the rules and the result? Yet by their fruits shall ye know them. Law is, to the community, what law does. What picture of the doing can you find in all this study of appellate courts alone? Again, as so often, I have no remedy. One thing of great importance we can offer: the wherewithal to discover the official version of the rules, and some experience in how the highest of judicial officials work with them. Some practice, too, and some information as to what they mean to laymen whose affairs are big enough to call for taking thought about the officials. We can, too, call attention, now and again, to the limitations of the picture thus set up. But we cannot keep the picture from distortion as you go more and more deeply into a single part of it, neglecting all the others. We cannot take you into the other parts. We have neither the wit nor the knowledge, neither we nor any man. A first beginning has been made, is being made, at getting the necessary knowledge. No more. A first beginning. We have achieved in this the first stage on the road to wisdom. Some few of us have begun to guess how limited the knowledge of any of us is. For you, meanwhile, the task of setting yourself so far as in you lies to question always as you go, what lies beyond? To whom does this rule mean anything at all? And how much, even to that man, does it mean?